An arrest warrant is a warrant issued by a judge or magistrate on behalf of the state, which authorizes the arrest and detention of an individual, or the search and seizure of an individual's property. Arrest warrants are issued by a judge or justice of the peace under the Criminal Code. Once the warrant has been issued, Section 29 of the Code requires that the arresting officer must give notice to the accused of the existence of the warrant, the reason for it, and produce it if requested, if it is feasible to do so. Check courts may issue an arrest warrant when it is not achievable to summon or bring in for questioning a charged person and at the same time there is a reason for detention. The arrest warrant includes: the arrest is conducted by the police. Following the arrest, the police must within 24 hours either hand the arrested person over to the nearest court or release the person. The court must immediately interview the arrested person, who has the right to have an attorney present. Unless the attorney is not within reach, the court has 24 hours from the moment of receiving the person from the police to either order remand or to release him. Reaching the maximum time is always reason for immediate release. Detaining a person is only allowed under certain conditions defined by the Basic Law for the Federal Republic of Germany. In Article 104, the fundamental law determines that only a half-stricter arrest warrants serve the enforcement of the proper expiry, for instance in the Code of Criminal Procedure, but also in the Civil Procedure Law and in the Administrative Law and the Special Administrative Procedures after the Tax Code, the Finance Court Order or the Social Court Law. Article 2. Every person shall have the right to free development of his personality insofar as he does not violate the rights of others or offend against the constitutional order or the moral law. Every person shall have the right to life and physical integrity. Freedom of the person shall be inviolable. These rights may be interfered with only pursuant to a law. The procedure for issuing arrest warrants differs in each of the three legal jurisdictions. In England and Wales, arrest warrants can be issued for both suspects and witnesses. Arrest warrants for suspects can be issued by a justice of the peace under Section 1 of the Magistrates Courts Act 1980 if information is laid before them that a person has committed or is suspected of having committed an offense. Such arrest warrants can only be issued for someone over 18 if at least one of the following is true. Arrest warrants for witnesses can be issued if, in Scotland, a warrant to apprehend may be issued if a defendant fails to appear in court. In Northern Ireland, arrest warrants are usually issued by a magistrate. For the police to make a lawful arrest, the arresting officer a valid arrest warrant. A valid arrest warrant must be issued by a neutral judge or magistrate who has determined there is probable cause for an arrest, based upon sworn testimony or an affidavit in support of the petition for a warrant. The arrest warrant must specifically identify the person to be arrested. If a law enforcement affiant provides false information or shows reckless disregard for the truth when providing an affidavit or testimony in support of an arrest warrant, that may constitute grounds to invalidate the warrant. These minimum requirements stem from the language contained in the Fourth Amendment. Federal statute and most jurisdictions mandate the issuance of an arrest warrant for the arrest of individuals for most misdemeanors that were not committed within the view of a police officer. However, as long as police have the necessary probable cause, a warrant is usually not needed to arrest someone suspected of a felony in a public place. These laws vary from state to state. In a non-emergency situation, an arrest of an individual in their home requires an arrest warrant. Probable cause can be based on either direct observation by the police officer or on hearsay information provided by others. Information the police bring to the neutral and detached magistrate must establish that, considering the police officer's experience and training, the officer knows facts, either through personal observation or through hearsay, that would suggest to a reasonable, prudent person that the individual named in the warrant committed or was committing a crime. From 1964 to 1983, a constitutionally adequate affidavit comprised exclusively or primarily of hearsay information had to contain information suggesting to the examining magistrate that attending an informant's tip, The individual issuing the arrest warrant need not be a judge or an attorney, but must be both capable of determining whether probable cause exists as well as be a neutral and detached official. While arrest warrants are typically issued by courts, they may also be issued by one of the chambers of the United States Congress or